A single email destroyed a $1.2 million trust claim. Drawing from decades of family trust battles, I'm revealing the devastating mistakes that hand your inheritance to your siblings. The evidence trick later in the video can make or break your case. Picture this. Your parents spent years building their estate, planning for your future, making sure everything was in order. They created a trust, thinking it would prevent fights, keeping things simple and make sure their wishes were followed. But here you are, embroiled in a trust contest with your sibling, fighting over what you both believe is rightfully yours. Sound familiar? This is the reality of many families in Florida facing a sibling trust dispute. Trust contests are emotionally charged, legally complex, and financially draining. Florida law lays out specific rules for challenging a trust, and today we're going to break them down in a way that makes sense so that you can understand what's at stake and how to navigate the process strategically. Why do siblings contest trusts? The most common reason falls into a few major categories: undue influence, lack of capacity, and trust validity. Let's start with undue influence. Imagine an aging parent who becomes more dependent on one child. Maybe that child lives closer, manages doctor's appointments, and helps with finances. Over time, that child becomes the primary decision maker, and suddenly the trust is changed to favor them heavily. When the other siblings find out, they suspect undue influence. Under Florida law, undue influence occurs when someone exerts excessive control over a person to the point that their free will is overpowered. It's a difficult thing to prove, but courts look at factors like sudden changes to the trust, secrecy, and whether the alleged influencer was involved in the drafting of the trust documents. Now let's talk about lack of capacity. A parent suffering from dementia or Alzheimer's may not have the mental ability to fully understand what they were doing when they signed the trust. Florida courts define lack of capacity as an inability to understand the nature of one's assets and who should logically inherit them and the consequences of the documents being signed. If you're challenging a trust on this basis, you need strong medical evidence, doctor's reports, witness testimony, and even expert evaluations. Without this, the burden of proof is nearly impossible to meet. That brings us to trust validity. Not all trusts hold up in court. Maybe the document wasn't properly executed. Florida law has strict requirements. Was the trust signed in front of two witnesses? Was it notarized? Was it created under duress? If any of these factors come into question, you might have grounds to challenge the trust. Now let's talk about one of the biggest obstacles to contesting a trust: the no contest clause. Some trusts include language that says if a beneficiary challenges the trust, they forfeit their inheritance. But here's the good news. Florida law does not enforce these clauses. Even if a trust says you lose everything if you challenge it, the provision is void. You have the right to contest a trust without automatically giving up your inheritance. But rights don't mean much without evidence. In any trust contest, the burden of proof is key. Who has to prove what? In Florida, if you are alleging undue influence, it's your job to show that the influencer had control over the trustor, that the changes were suspicious, and that there was a confidential relationship. But if you meet this burden, the burden shifts to the accused influencer to prove that everything was fair and voluntary. This shifting burden can make or break a case. Let's say you're ready to move forward with a trust contest. What does that process look like? Well, the first step is filing a formal petition in probate court. Timing is crucial. Florida law sets strict deadlines, and missing them means losing your chance to challenge the trust. Once you file, expect a legal battle. Discovery, depositions, expert witnesses, financial reports. This is not a quick or cheap process. So what are your options if you want to avoid a prolonged court fight? Settlement is always on the table. Many sibling disputes are resolved through mediation, where the parties negotiate a compromise instead of spending years in litigation. This can save time, money, and most importantly, relationships. Because let's be honest, no matter how this shakes out, at the end of the day, this is still a family. Winning the case but losing your siblings may not feel like a victory at all. Well, what about the costs? Legal fees, court costs, expert witnesses, it all adds up. Some attorneys work on contingency, but many charge by the hour, and trust litigation can quickly turn into the tens of thousands of dollars. This is why it's essential to evaluate your case early. If you have strong evidence, it might be worth fighting. If your case is weak, a strategic settlement may be the smarter move. Finally, let's talk about the big picture. What happens after a trust contest? If you win, the trust may be invalidated and assets may be distributed differently, sometimes reverting to prior versions of the trust. If you lose, the trust remains as written, and you may even be responsible for the legal fees. Either way, the impact extends beyond finances. Families can be torn apart, sibling relationships can be damaged beyond repair. That's why it's critical to approach this process with both a legal strategy and emotional awareness. Trust contests are never just about money. They're about fairness, about honoring a parent's wishes, about feeling seen and heard. If you're facing a sibling trust dispute in Florida, know your rights, gather your evidence, and be strategic. Sometimes the best fight is the one that ends before it even begins, with a well-negotiated resolution that keeps your family intact. Thanks for tuning in, and if you have any questions about this or other legal topics, drop them in the comments below. Don't forget to like, subscribe, and share this video if you found it helpful. Until next time, stay informed and stay protected.